All right, so now we're going to talk about encumbrances on real property. And this is a crucial topic in real estate law, as virtually all real property is encumbered to some degree. Okay. So understanding these is essential for anyone who's dealing with real estate, whether you're representing the buyers, the sellers, the lenders, or the property owners involved in the disputes. So let's start with the definition of an encumbrance. An encumbrance is an interest in real property that is held by someone other than the owner of the property. So think of it as a right or a claim that a third party has over another's land. Okay. And encumbrances are going to fall into two very broad categories. The first is an encumbrance that limits an owner's use of real property or permits others to use it. The other is a lien, which is going to represent claims on real property that provide security for the payment of a debt or an obligation. And these are financial claims against the property itself. Now, let's talk about the features because the most critical feature is that encumbrances generally run with the land. That means that they attach to the property itself and they're not extinguished by the changes in ownership. So, when a property with an encumbrance is sold, the new owner typically takes the property subject to that encumbrance. That's why a title search and a very thorough title search is the utmost importance when it comes to a real estate transaction. Encumbrances are generally considered undesirable because they place limitations on a property's owner's bundle of rights. Okay. They restrict what an owner can do with their property or to impose financial obligations on it. However, it is also important to note that virtually all real property is encumbered to some degree. For example, even a simple mortgage is an encumbrance. Now let's look more specifically at encumbrances affecting the use of real property. Now, these are the non financial restrictions or allowances that are going to dictate how property can be used. And this category includes things like easements, leases, licenses, and even the significant impact that subdivision, condominiums, or co op covenants can have on the use of real property. So, first is an easement. And this is a right that may be exercised by a third party on, over, or through real property that's owned by another for a specific use. And like many other encumbrances, easements typically run with the land. Okay. So they attach to the property and typically transfer with ownership. Now, easements may be granted to private parties, public utilities, or to the government. Now, let's break it down a little bit further into the categories of easements. You have an easement in gross, and these easements benefit a certain, like very specific third party. Okay. They are personal to the grantee and typically do not attach to a particular parcel of land. For example, a utility company having an easement to run power lines across your property, right? That easement benefits the utility company directly and not the land. Then you have the appurtenant easements, and these are easements that benefit a parcel of land rather than a specific third party. So these involve two distinct parcels of land. So you have the dominant tenement, which is the property that benefits by the easement. So it gains the right of use over another property. Then you have the servient tenement. And this is property that is burdened by the easement. So it's the property over which the right is exercised. So imagine that you have two pieces of land, right? Lot A, lot B, right? But lot B is landlocked, meaning that there's property all the way around it, right? But it needs a way to get to the road, okay? So the owner of lot A grants the owner of lot B an easement to cross a portion of lot A in order to reach that public road. By the way, this is also called a necessity. So it's one of those things that is required for, lot B to be able to use. Now, lot B in this case is the dominant tenement and lot A is the servient tenement. So this easement is going to run with the land, meaning that if lot B is sold, the new owner still has the right to use that easement. Okay. Now, appurtenant easements, these can be affirmative, meaning that they allow a right to do something like cross the land. Or they can be a negative, which restricts the servient owner from doing something like maybe blocking light. Okay. Now, you also have reciprocal easements, and these are easements that benefit and burden both parcels of property that are involved. So let's say that you have a shared driveway situated on, the property line between two neighbors. Okay. Each neighbor grants the other an easement to use the portion of the driveway that's on their land. So now let's talk about the formation of easements. First is by express, and this is the most common and the most straightforward way. And an easement that is created through like an explicit agreement, through a deed, through a will or testament, right? It typically requires a written document and the same formalities as conveying property. Okay. So a property owner would sign a formal like easement agreement that grants their neighbor access to whatever, a shared driveway, a shared well, whatever. Now you have by reservation. And this occurs when a grantor conveys a parcel of land, but retains a portion of the parcel for their own benefit, right? So if you sell a large piece of land, but you want to retain the right to access a fishing spot on that land, then you can reserve an easement in the deed of sale. Then you have by implication, which is also known by necessity, which is what I talked about just a second ago. And this comes up whenever there is, you have a landlocked parcel of land. So when a larger parcel gets divided and one parcel becomes landlocked, an easement is implied by law to provide necessary access to a public road, right? The law presumes that parties intended for access to exist. So if a large landowner, like I said, sells off all surrounding parcels, but leaves an interior one with no access, ability to the road, then an easement by necessity would be implied over one of the adjacent parcels. Now, you also have by prescription, and this is similar to adverse possession, but for the right of use. And it occurs through adverse possession / use. So to establish an easement by prescription, you must generally be, again, open and notorious. It has to be adverse and hostile, which means without permission. And it has to be continuous and uninterrupted for whatever the statutory period is. And here in Georgia, it's either 7 years or 20 years, depending on which way it goes. But for example, if a neighbor consistently uses a path across your property to access, say, a public park for decades, and it's openly and it's without your permission, then they might be able to claim an easement by prescription. So easements, while they are generally, long lasting, they can be terminated. So let's talk about some of the common methods for the termination of an easement. You have by an expiration date or like by a specified event. So if the easement was granted for a specific duration or until like a particular condition was met, it would then terminate automatically when the time passes or that condition occurs. So for example, if you have an easement that's granted for a period of 15 years or until a new public road is built, then it can terminate. And that would go for like one that's landlocked. Maybe there's only one way to get to a road, and that's because no other roads have been built yet. But once those other roads get built and there is a new possibility, then that easement would terminate. Now you have by abandonment, and that requires more than just non-use. It requires an intent to abandon that easement. And it's typically evidenced by some kind of affirmative act by that dominant tenement owner. Okay. So if the owner of, say, a landlocked parcel builds a new access road on their own property and then fences off the old easement, that's a good indication that the intent is no longer to use it. Now, you also have by the merger of the dominant and the servient tenements. So if the same person or entity comes to own both pieces of land, then the easement is extinguished because you cannot have an easement over your own land. So, example, if the owner of the landlocked parcel buys that adjacent property where that easement runs, it ends. You can also have it by release. And that would be where the dominant tenement owner can formally release their rights to an easement. And again, it's usually through a written and recorded document. Okay. So they would sign something like a release of easement form, again, which officially kind of relinquishes their right to use it. But beyond easements, though, there are other encumbrances that affect property use. First up is the lease. And a lease is a contract that conveys a possessory interest in real or personal property. And it's going to grant a tenant an exclusive right to occupy the premises for a defined period. And that right generally ends with the expiration of the lease. Okay. Now, for our purposes, a lease is going to run with the land. So when you rent an apartment, you have a possessory interest for the lease term. The landlord still owns the property, but your lease is an encumbrance that is limiting their ability to occupy or use it during your tenancy. But if the landlord sells the property, then the new owner is going to take the property subject to your existing lease. Next up, we have the license. And a license is permission or authority that's given to a third party by the owner of the land to do a particular act or a series of acts on the licensor's property. Okay. So unlike an easement and a lease, a license doesn't usually run with the land. It's generally a personal revocable privilege. All right. So let's say inviting a guest to your home grants them a license, right? This permission can be revoked at any time. A ticket to a concert grants a license to enter that particular venue. All right. The key distinction here is that easements are generally property rights that transfer with the lands, and licenses are temporary and personal permissions that do not. Now let's discuss the restrictions and obligations of subdivisions, condominiums, and co-ops. And these forms of community living impose specific restrictions and obligations that direct the use of property within that specific community. A subdivision is a tract of land that has been divided up into several smaller parcels where you have detached single family homes that can be built. Okay. And within subdivisions, you'll commonly find things like a homeowners association. And these are the people that manage and maintain common areas and enforce community rules. And a lot of people would argue that they're a pain in the butt. You also have restrictive covenants. Okay. And these are rules and regulations that are found in a recorded document. And it's usually a declaration of covenants, conditions, and restrictions. And these run with the land and they bind all current and future property owners. For example, you might have restrictions on a fence height or paint colors or landscaping or requirements for homeowners association approval to do any kind of exterior modifications. And these are significant encumbrances because they actually limit the owner's use of their own property. Now, a condominium is a building or a complex in which units of property are owned by an individual, and the exterior of the buildings are jointly owned and maintained by all of the residents of the complex. Okay. And this is where we have a condominium declaration. Okay. And this is the foundational legal document for a condo. It's going to outline the ownership boundaries, the common elements, the voting rights, the maintenance responsibilities, and the use restrictions. Okay. So, for example, like rules regarding pet ownership or noise levels or rental restrictions or like assessments for common area maintenance. Those rules are legally binding and are encumbrances upon the individual unit ownership. So, a cooperative association or a co-op, it consists of a multi-unit building that is owned by a nonprofit corporation in which the individual unit owners of the building own shares of stock in the corporation. So you don't directly own your unit. You own shares that grant you a proprietary lease. And co ops are primarily found in specific markets like New York and Florida and California and DC. And the rules of the co op board and the proprietary lease are going to function as encumbrances, which often give the board significant control when it comes to unit transfers. Now, finally, let's talk about liens. Liens are a third party claim on real property that's held as security for the payment of debt or other obligation. And they essentially represent a financial interest that is held by a creditor against the property. Okay. And liens are often referred to as clouds on title because they indicate an outstanding financial claim that could lead to the property being sold to satisfy the debt. Now, liens can be categorized in two ways. You have voluntary or involuntary, which is created with or without the owner's consent. And then you have specific or general, which is attaching to a particular piece of property or all of the debtor's property. Now, let's talk about them in a little more detail. The voluntary liens are created with the property owner's consent, and they attach to a specific piece of property. And they are the most common type, and they're like mortgages or deeds to secure debt in Georgia. So, when you take out a loan to buy a property, you grant the lender a lien on that specific property as collateral. All right. Then you have UCC liens. So, while primarily for personal property, UCC liens can sometimes attach to real property, especially in the context of fixtures. Then you have bail bonds, which is real property that can sometimes be used as collateral for a bail bond when getting somebody out of, jail. Then you have involuntary liens, and these are specific liens. They are imposed on a specific piece of property by operation of law, and it's without the owner's express consent. Okay. Real property tax liens. So these are placed by the government for unpaid property taxes. And these have priority over most other liens. You have municipal service liens. These are things for like unpaid services like water or sewer. Then you have special assessment liens. And these are imposed for public improvements, specifically benefiting the property, like new sidewalks. Then you have a mechanics and material men's lien. And these are filed by contractors, laborers, and suppliers who haven't been paid for work or materials on a specific property. Then you have an HOA, condo, and co-op liens. And by the way, condos can also have a COA, which is just the Condominium Owners Association. But these liens would be for unpaid dues, assessments, or fines by the property owners within those communities. You can also have an attorney's lien, which in some jurisdictions, attorneys can place a lien on clients' property for unpaid legal services. You can have motor vehicle bonds. And in specific legal contexts, a bond related to a motor vehicle issues, it might be secured by real property. You have commercial real estate broker liens. So in Georgia, commercial real estate brokers can have a lien for unpaid commissions from a sale or a lease transaction. Then you have an involuntary lien, which is like all judgment liens, and those attach to all the debtor's real property. And sometimes they're personal property within a certain jurisdiction. Then you have judgment liens, and these are where you have a creditor who obtains a monetary judgment from a court and then they record it. And it creates a lien against all of the debtor's real property in the county. Then you have a lis pendens, and this is not a lien itself, but it is a recorded notice indicating that a lawsuit affecting title to the real property is pending. So this acts as a cloud on the title, and this will come up in family law. Then you have income tax liens, and these are placed by federal or state governments for unpaid income taxes. And that's really it. Just remember that encumbrances are third-party interest in real property that, again, run with the land, okay? Certain encumbrances will affect the use of real property, like the easements, the leases, the license, and those restrictive covenants. Other encumbrances, they represent claims to the property to secure a financial obligation by the property owner, and these are liens. So, um, again, this knowledge is essential if you're going to work in real estate, especially for ensuring there's clear title, that property interests are protected, and just being able to kind of navigate the real estate transactions effectively. If you have any questions, let me know. Bye.